Hello, my name is Matthew Thrift. I am one of the brokers in charge at Berkshire Hathaway Home Services, Sedan Joiner Realtors here in the upstate of South Carolina, and I actually broker the Simpsonville and Greer offices of our firm. Today we're going to be discussing the South Carolina Association of Realtors Form 220, otherwise known as the Exclusive Right to Sell Listing Agreement. I want to make sure that everybody understands I'm a broker in charge. I'm not an attorney. So I'm going to explain this form to the very best of my knowledge so that you have the best understanding of it as well, so you can explain it to your sellers. Now, as a human being, I can make mistakes. If there's something in here that you don't agree with, that you think I made a mistake on, or that your broker says to do differently, please, I implore you, check with your broker. Always check with your broker of whom you are associated with. So the first section doesn't really have a number. It's just basically the basic information. Who are the sellers? Who is the listing brokerage? You see it there in that blank line. You put your seller 1, your seller 2, how many sellers that you have. Obviously, if you need more room, you can use an addendum for that, for if you have multiple sellers. Also, in our company, it's okay, since this is not a marketable document, we can use the acronym BHHS, Sedan Joiner Realtors. You do not need to have your office, for example, Simpsonville or Greer. It's just Sedan Joiner Realtors, since we're all one large company. It's going to continue on in that second paragraph there for the beginning start date. That's pretty self-explanatory, and at the next blank line there, the ending date, that's pretty self-explanatory. You need to have a start and end date for your listing agreements. If you don't, it's considered not a it's considered a voidable listing agreement. Everything contracts have to have a start and end date. Fill out your lot, block, section, and subdivision, especially your subdivision. And going down below, that's pretty easy. Fill out your address in its entirety. Definitely don't miss your tax map number. If you are listing more than one property for these same sellers, let's say the tax map numbers are attached, my preference is that you have a separate listing agreement for that particular tax map number. Remember, in MLS, you can only list one tax map number. So I would prefer to have a totally separate listing agreement if you're listing more than one tax map number. And in the MLS, just refer back to each tax map number within your member remarks. The next section there talks about any other property that's going to be sold. Now remember, we don't sell real property, but our lenders do allow us to have a refrigerator, washer, and dryer. Now, for the most part, most loans allow refrigerator, washer, and dryer to be actually in the real estate contract. So if your sellers want you to just list that as part of the house sale, you can go ahead and put that there if you prefer, or anything else that's necessary right there, you can do so. Now let's go on to actually section 1. Section 1 is the consent to disclose dual and designated agency. And that first line, when a seller or sellers initial there, they're stating that you as the listing agent have provided them the meaningful explanation of brokerage relationships or agency, from the South Carolina Disclosure of Brokerage Relationships document promulgated by the LLR, that you've provided a meaningful explanation of that, and you've also provided them a copy of that, so they understand the differences between single, dual, and designated agency. Now, the second and third line there allows a seller to decide whether or not they're going to agree or not agree to dual agency. Some sellers only want you as the listing agent to represent them. They do not want you representing a buyer. You need to have that conversation up front. The same thing goes for lines 3 or 4. That is designed for designated agency, which we all know if you as a listing agent list a property and another agent within your office brings a buyer, the seller will be provided a time to say yes or no to designated agency. Now they can do that right up front here They can automatically say no right up front. Most of the time we see sellers saying, yes, it's okay for designated agency. But remember, in each of these, the dual or designated, if they're saying they will agree to it or think about it at the time, on lines 3 or 5 there, remember, if either one of those things happen, you must have a separate dual or designated agency document signed by all parties. So just keep that in mind if that does happen. There's not a whole lot in that section. Let's go into section 2. Section 2, terms of the agreement. The very first line says the broker agrees to employ broker's best efforts to sell or to secure a contract for the sale of the property for a price of, and then you have a line there which you're going to spell out, $200,000. In zip forms and DocuSign, they make this very easy, but in the next line there, you actually have to write the dollar amount as well. Now, in the next few lines, it says whether or not you're going to have a flat fee sales amount or agreement and the dollar amount there, or you're going to use a commission percentage rate of the sales price of the property. So flat fee or percentage, whatever your company policy states. I'm not going to go into commission rates on this video because this is going out to multiple other companies who have their own policy. But just know you can either do a flat rate listing or you have a percentage of the sales price of the property. It also says the owner and broker agree that there shall be no variation or exception in the amount of fee or commission to be paid unless specified in paragraph 28, which is the other terms and conditions. So if there's going to be any adjustable rate, remember that has to be disclosed within the MLS, meaning that if they're going to allow dual agency or designated agency and you bring the buyer and you're charging one fee, if you don't bring the buyer but yet you do, you can have an adjustable rate, or the office, you can have an adjustable rate commission for that seller, and you can discuss that in section 28 of what that adjustable rate will be. The last portion of that paragraph there, it says broker agrees to defer the commission until the closing date or extension thereof stated in the agreement or until default by owner. Deferral is agreed to solely as an accommodation to owner, and such deferral shall in no way be construed as a waiver of the brokerage fee. The closing attorney is hereby irrevocably directed to deduct and pay said broker's fee from the proceeds of the sale. So basically, in this section, it states that once you provide or bring a ready, willing, and able buyer and they go under contract, you have earned your commission, you've earned your pay. But this document states that you're not going to get paid. We're going to defer that payment until the closing, and the closing attorney will pay you at that time, or pay the brokerage at that time for bringing about that sale. The last portion of section 2 says if the property is sold within so many days of the expiration or termination of this agreement, it's the protection period, to a buyer to whom the property was shown by the owner, broker, or another broker, or any other person or firm during the time of this agreement, the broker's full fee shall be payable by the owner. This protection period shall be terminated if owner enters into a listing agreement with another broker during the protection period. For the purposes of this agreement, a sale shall be defined as any transfer of a legal, equitable, or beneficial interest of the subject property, whether for money or in exchange of another property, and shall include, but not be limited to, any transfer of the ownership interest in any corporation, limited partnership, or other entity. Basically, if the owner decides that they want to cancel the agreement, and that property was shown to a buyer by you, any member of the firm, or any member of the other company, another company, or the owner themselves, the owner cannot sell that property to any of those people in that protection period unless they sign another listing agreement, and that goes into effect with either the same firm or another firm. The protection period goes away the very second they enter into another listing agreement with another firm. So I want to make sure everybody understands that. Let's go into section 3, compensation to other brokerages. Section 3 discusses the compensation to other brokerages. And I'm not going to read it all. Basically, in our brokerage in Berkshire Hathaway City and Joiner Realtors, our policy allows us to pay buyer's agents, and it allows us to pay transaction brokerages. So we're not going to pay sub-agency. It's against our policy. If you're watching this video and you do not work for Berkshire Hathaway, please check with your broker. Please check your policy manual. Your policies may be different than ours. But in this company, our policy is that we pay listing agents, pay buyer's agents to bring buyers, and we also pay those agents that only have a customer in the transaction. Therefore, they're not being fully represented under single agency. They're being brought to the transaction by the agent as a customer in South Carolina. Therefore, we are going to pay them a transaction brokerage fee to bring them to buy our property. This is just good practice as far as what our company has decided and is concerned. We want to give our sellers the most people looking at their property, and that's one of the reasons why we pay transaction brokerage as well as buyer's agents. So therefore, it's pretty simple. You either put a percentage there or you put the flat fee, and that's going to also go in your multiple listing service listing. So therefore, these two need to match up. And BA in your MLS, or it could be something else, it's BA in the Greenville MLS, should match that number. And then TB should match the transaction brokerage number that you have there. Other than that, that's all there is in Section 3. Let's go on to Section 4. Section 4 talks about earnest money, and basically this entire section is the seller providing authority for an escrow agent or escrow holder, such as the brokerage or the closing attorney or an escrow holder of some sort, that all earnest money will be deposited within an escrow agent's account for the purposes of that money being credited to the seller at closing. The seller is providing authority. But what I really want to go over is just underneath that section where it says, owner understands that under all circumstances, including default, broker will not disperse earnest money to either party until both parties have executed an agreement authorizing the disbursement or until a court of competent jurisdiction has directed a disbursement. Please get that a point to your sellers. If there's a default by the buyer during the contract for sale, just because the seller may think that they're owed earnest money for a default or some other reason, unless there's a meeting of the minds and both parties agree for that disbursement, money will sit in an escrow agent's account, especially a real estate brokerage's account. Now, if an attorney's holding it, an attorney's office, an attorney escrow agent is not held under the same standards as a real estate brokerage trust account. And the attorney may have their own escrow disbursement agreement based upon the circumstances. And so we're seeing a lot more of that in 2020. So just make sure that when earnest money is held by an attorney, that an escrow disbursement agreement, hopefully they have one, and that the seller gets a copy of that so they know exactly what's going to happen, especially when the property goes under contract, if there was some sort of default with their earnest money. If it's held by a brokerage, which our brokerage, Berkshire Hathaway Home Services, City and Joiner Realtors, has gotten to a point where we're no longer holding escrow money. We will in absolute extreme circumstances, but we are directing all earnest money to be held by our attorney of choice or by the closing attorney. So just make sure that you let them know if we did hold earnest money and there was a dispute, our company would not release earnest money unless both the buyer and seller sign an agreement or a court of competent jurisdiction tells us how to disperse this agreement and maybe an interpleader action or some other court action. Other than that, let's go on to Section 5, short section. Section 5, signs. We all want a sign in the front yard of our listing. Everybody wants a sign. At least most agents do. Sometimes sellers don't. So, This section is really, really simple. I'll read it. It's short. Owner grants to broker the exclusive right to display for sale, under contract, sale pending, or other similar signs on the property and to remove other such signs. They're giving us permission to do so right then and there. Point that out. If your seller says they don't want any signs at all, you may need to have them remove that or get their attorney to remove that by scratching that out. But they're providing us permission right up front. Other than that, there's not a whole lot to that section. We're going to go on to section 6. Section 6 talks about the broker's duties, and basically it says what the broker is going to do for the seller. I'll just read a little bit here. Broker agrees to employ the best efforts of broker and broker's agents and staff to secure a contract of sale for the described property upon such terms as may be agreeable to the owner. That's a very broad statement. The listing brokerage is stating there that they're going to do everything they possibly can to make sure that they bring the seller a contract so they can get the property sold. That's the reason for this agreement. It goes on to say a few other things to keep the seller informed of everything that's going on, that they're going to advertise the property in multiple advertising medias of merit customarily used in the area, furnishing such additional information such as necessary to cooperating real estate brokers, especially the MLS. I mean, it just basically goes into everything that we're going to do to bring about a contract of sale. And also at the last line there, broker shall keep confidential all information received during the course of this agreement, which was made confidential by written request or instructions from the client, except as provided under South Carolina law. Basically, you owe the seller a duty for confidentiality. Please keep your confidentiality. That could be considered a violation of real estate law as well as a violation of the Code of Ethics. So, do your best efforts to get the property sold. That is your duty as a listing agent as well as your listing brokerages. Let's go on to section 7. Section 7, as you can see there, is in italics, and this is in our buyer's agency agreement as well. And this, I get a lot of questions on this section because it tends to have some wording in there that would make possibly some sellers and or buyers uncomfortable. And a lot of agents have a difficult time explaining this because of some of the wording in here. Not that it's wrong. Remember, SCR, South Carolina Association of Realtors, protects their members. LLR protects members of the public. So this is a protection clause for us. And instead of me reading it and getting you all confused, let me basically explain this section. Basically, it says everything that we're doing, we're providing services, we're providing advice, we're providing benefits and assistance and value to the seller. But if you or the listing brokerage does something in error or unintentional that the seller is not in agreement with or may cause the seller a loss, this section states that if the seller decides to file a lawsuit, that the seller would only be entitled to obtain that of which they would have paid you to get the property sold, basically the commission amount. If you do things that are not willful or intentional to cause the loss. If it's just an accident, they don't like it, they take it to court. By this contract, they're only, it says that they're only able to get what their commission amount, what they would have paid you, not exceeding. The problem is that people have a tendency to read on in this because it says, as well as covering all of the fees and court costs for the agent. So that's where we run into a little bit of a problem that sellers may not like that. It says that they're going to cover your court fees and costs. It also says that the seller will hold harmless and indemnify parties that the listing brokerage or the listing agent has recommended. For example, home inspectors or professional service providers of some sort. If they do something and the seller goes after them, this document says that they're going to hold the agent harmless. You really need to know this section because this is a pretty important section. People want to know that they have some rights. So just read that, put it in, maybe highlight a few different words and let them see that. Now, if there's a problem with a seller with this area, my recommendation is to have them contact a real estate attorney or another attorney, have the attorney explain this section as well. And if the attorney and them want to get together with how they want to change this, that is totally up to them and the attorney, and there needs to be an agreement between you or the listing broker, the listing brokerage, to find out whatever changes need to be made. I'm not recommending changing a contract whatsoever, especially for agents to do that. That's the unauthorized practice of law. So have an attorney look that over if there's any problem with the seller in this section. It's my professional advice and opinion. Other than that, let's go into Section 8. Section 8 talks about the owner's duties. Now, if you're going to spend a lot of time here, in any other area of this contract, I would suggest you spending the most of your time here so sellers know exactly what you need their help with. Remember, selling a home between an agent and a listing brokerage is a partnership. It's a symbiotic relationship. Therefore, owners need to do something to help you and the listing brokerage get the property sold. So we're going to go through a few of these. To furnish broker with complete and reliable information. Well, that's a given. We need to know everything we need to know about the property so that we can sell it with all proper information, and to disclose anything that we need to disclose. We need to know that. To inform broker of any inquiries from other brokers or negotiations concerning the sale of the property. That's pretty simple. To permit inspection and showing of the property by broker, the broker's agents or sub-agents, buyer's agents, and by such agents, sub-agents, and prospective buyers as deemed reasonably necessary by a broker, and to cooperate in the scheduling and carrying out of such showings and instructions as is necessary. Basically, to let people in to see the property, to help us show the property so we can get it sold for them. To permit offering for sale of the property to prospective buyers without regard to age, sex, race, creed, color, religion, national origin, handicap, or familial status. We don't deal with discrimination here at Berkshire Hathaway Home Services, Cedar and Joiner Realtors. We need the sellers not to do that as well. That could be considered a fair housing issue, and we could get the federal government involved. We don't want that to happen. We need to make sure there's non-discrimination totally across the board. This section E, sometimes I get a lot of questions on this because there's a blank line there for a dollar amount. To permit broker to incur or pay on behalf of owner reasonable expenses for repairs, inspection, utilities, maintenance, or similar expenses not to exceed a dollar amount for each separate expense, and to reimburse broker as necessary upon receipt of the statement of expenses. So here's a hypothetical. So if I'm listing a property, or if you're listing a property, and the seller is out of town for several weeks in the summer, and you know that the grass is growing, in this section, the seller can actually provide up to a certain dollar amount for you to make sure that the yard is being maintained and to pay the landscape vendor for that, and then the seller will reimburse you those expenses. That's just a really quick way to explain that section E. And it says to allow closing attorney to pay brokers compensation in an amount equal to the compensation provided above. Remember the section that we were talking about in section 3, from owner's proceeds at the time of closing. Again, at the bottom of the page, you have some initials there for all the owners and for the listing agent to initial. On page 3, we go on several more duties for the seller, I should say. To grant to broker the authority and approval to list and publish all sales data pertaining to the sale and closing of the herein above described property. Owner understands and acknowledges that sales data are published for the use of information from members of the boards and associations. Basically, once this property sells, we're going to publish that so other agents can use that for their comparative market analyses and other stuff like that for sales data. So they're giving us permission to do that. H, to permit broker to take photographs. and for advertising and marketing purposes and advertising mediums with those photographs. Let's see, it says owner understands and acknowledges that all marketing materials, including but not limited to photographs, brochures, and websites developed for the sale of the subject property shall remain the property of the broker. Just because you take photographs of a person's house, they are not owned by the seller. I, to convey marketable title to buyer in fee simple, free from all liens except those stipulated herein, subject to existing zoning and government restrictions applicable, owners association assessments and restrictive conditions and covenants of record which do not materially affect the present use of the property, and J, to authorize owner's attorneys and the settlement agent to furnish to broker copies of the final settlement statement for the transaction prior to the closing date. It says K, not to deal directly with prospective buyers. That's huge. They need to refer to you, the sellers need to refer to you, any buyers that contact them, not to deal directly with prospective buyers of this property during the period of this agency, and shall refer, shall, not may, shall refer any inquiries received directly and immediately to the broker. Now, L. This is huge because this is also within your code of ethics. L, to authorize the broker in response to inquiries from buyers or cooperating brokers to divulge the existence of offers on the property. The code of ethics states you must provide that information if given permission by the seller. This listing agreement provides you permission to give the existence of multiple offers on a property or the existence of other offers on a property. It does not give you permission to tell them the price of the offer. It says to give them permission to divulge the existence of offers on the property, just like your code of ethics says. So just make sure they understand that as well. An M, last portion, to furnish broker with written instructions regarding the confidentiality of information upon termination or completion of this agreement, which was received during the course of this agreement in accordance with South Carolina law. If they specifically want you to maintain confidentiality on something specific that may not necessarily be confidential, they need to write that in instructions to you. Other than that, let's go into Section 9. Section 9 talks about the seller's disclosure and the fact that the seller is going to provide one to you. Now, remember, there's some exemptions in there where listings will not have a seller's disclosure. But in general, and for the most part, all listings that we have, for the most part, unless it's an estate sale or a foreclosure or a transfer from one family member to another, for the most part, you have seller's disclosures in our listings. So it talks about that the seller is going to fill that out in its entirety. It also says in the middle of the section there, I'm not going to read it, it's fairly long. Read it, read it, read it. Read this contract over and over, know it like the back of your hand. But it also says that the seller will hold the listing brokerage harmless and indemnify them in the fact that any problems arose out of the filing of this document or filling this document out. Remember, we cannot touch this document at all. We can't fill it out for them. We can be a scribe if they're, let's say, for lack of a better example, if they were blind, we can ask them questions and be a scribe to them, but we can't answer questions or fill this out on their behalf. Let's go on to Section 10. Section 10 talks about disclosure, and there's a whole lot of disclosure that we can refer to here, but basically it says that the seller is going to provide to the broker, the broker's agents, it says subagents and prospective buyers, they're buyer's agents, they're going to disclose anything about the property that they know. It says such disclosure shall be in accordance with broker's company policy, and it says owner hereby authorizes anyone having a lien against the property. So it's not just disclosing the presence of a problem or material fact. It says they're going to disclose the fact that they have a lien against the property, including the mortgage holder, to disclose complete information about the lien to broker and the closing attorney. So if they have a lien against property, it says they need to disclose it, so we know how to best advise them. And they need to disclose that to the attorney so they can get the final payoff. I mean, that's pretty self-explanatory, pretty easy. Let's talk about Section 11, taxes. Section 11 is taxes, and this is a short section. I'm going to read the entire thing just because there's some things in here that I really want to get across to you. Owner covenants and agrees to comply with the provisions of South Carolina Code Section 128580 as amended regarding withholding requirements of owners who are not residents of South Carolina as defined in the said statute. The payment of rollback taxes, if applicable, and past personal property taxes, if applicable, shall be negotiated between the owner and the prospective buyer. Remember, in our contract for sale and our raw land contract for sale, there's a decision whether who's going to pay rollback taxes. And if sometimes a person can't pay the personal property taxes, and a buyer is willing to buy the property and pay any property taxes that are owed on the property, that the buyer takes that on. Now, that's not often, but that does happen. And if you are representing a seller that's from out of state, there could be some, and more than likely there's going to be some taxes withheld for selling a property when you're not a resident of South Carolina. I wouldn't make any advice on that. I would have them speak to the closing attorney on that if they're a resident outside of South Carolina. Remember, we're not tax professionals, we're real estate agents. Stay in your lane, don't make professional tax advice. So that's the reason why I wanted to really kind of discuss that a little bit more. Let's go into Section 12. Section 12 doesn't really affect us here in Greenville, so to speak, because it's the Coastal Tidelands and Wetlands Act. This is more for the southern areas or the coastal areas of the state, but we'll talk about it in any case because other people are also watching this particular video, not just here in Greenville. It says, in the event the property is affected by the provisions of the South Carolina Coastal Tidelands and Wetlands Act, and it gives the section there, an addendum will be attached to the sales agreement incorporating the required disclosures. The payment of any necessary surveys shall be negotiated between the owner and any prospective buyer. So if the property is affected by it, there needs to be another addendum, and the other documents and disclosures that goes along with that. Again, it doesn't affect us here in Greenville, but other areas of the state this does affect. So please make sure that you have those addendums and those disclosures when that time comes. Let's go on to Section 13. Section 13 is the multiple listing service / public marketing section of the listing agreement. This is a very, very, very new section because MLS Clear Cooperation, the rule by NAR, the Clear Cooperation Policy, goes into effect on May 1st, 2020. And so this document now complies with our Clear Cooperation Policy of the National Association of Realtors. Because I want to read this entire thing so everybody has a total understanding of this section. Option 1 is basically your general option, which most people choose because most agents are doing on MLS listings. So not a major thing to understand here. It's pretty simple, but let's make sure that we read it together. Let's do it. The property shall be entered into the multiple listing services of which the broker is a member within the time frame stipulated by their bylaws and regulations. This shall constitute an offer of cooperating brokerage to all members of the listing service. The owner agrees that broker may compensate an agent representing the buyer from the fee described in paragraph 3. Remember the cooperating brokerages fee. The owner, and then they have the ability to check either one of the boxes. The owner does agree or does not agree that the listing will be placed in electronic marketing mediums, including but not limited to the internet, MLS Internet Data Exchange or IDX program, or other similar online computer services, and to share listing data, including the property address, with other members of MLS for marketing and advertising purposes only. Owner further agrees to permit other real estate firms who belong to any listing service of which broker is a member to advertise the listing on the internet in accordance with the listing service rules and regulations. All in bold here. The broker and owner agree to abide by all rules and regulations of the multiple listing service on which the property is listed. Now, there are several MLSs across the state of South Carolina. And so what I will say is this. It's referring to the Greenville Association of Realtors. The reason why that last line is in there is because if a seller signs this listing agreement in the Greenville MLS, you must abide by the rules and regulations of the MLS service to have the property entered into the MLS within 48 hours of seller signature. That's what our rules and regulations say. Once this document is signed in Greenville MLS, if you're the member there, that it must be entered into the MLS. Whether it's on a temporary off the market status or whether it's just a full active status, whatever the case may be, within 48 hours of seller signature. Now, if you're a member of other MLSs, there's multiple other rules across the state for how many days or how you should get the property into the MLS over the time frame, okay? So you need to check with them, but let's read that last line one more time. Broker and owner agree to abide by all rules and regulations of the multiple listing service on which the property is listed. So just make sure when you list a property, you understand the rules and regulations of your local MLS. Let's go to option 2, because this is where it gets obviously could be confusing, and this is where a lot of people can run into a lot of problems, okay? So again, this complies with NAR Clear Cooperation Policy, so we're going to read this full thing as well. The seller does not consent for their property to be placed on the multiple listing service and instead wishes to have their property listed as a brokerage exclusive. This will prohibit the seller, check that out, the seller and the broker from conducting any public marketing, which includes, but is not limited to, the following. Site signage. So you can't have your for sale sign, you can't have your broker sign in front of the property. Any social media and any communication, oral, written, or electronic, that can be disseminated to the general public of the property and will restrict the marketing of the property to only the members of the broker's firm. It restricts marketing to only members of the broker's firm. Broker and owner agree to complete any paperwork required by the multiple listing service of which broker is a member to verify that the property will not be publicly marketed. So let's stop there and let's talk for just a little bit. This is very clear. It is so crystal clear. If the seller decides on an MLS exempt or option 2 listing with you as a seller, as a seller's agent, you cannot market the property in any way, shape, or form to the public. Doesn't matter if it's on social media, doesn't matter whether it's in flyers, whatever the case may be. You can't do it. The only thing you can do as the listing agent is market within your firm. However many agents that is, you can tell every one of the agents, but once any sort of advertisement goes out on any public forum at all, the Clear Cooperation Policy says that you as a listing agent have 1 business day, within 1 business day, to have that property entered onto the MLS. If the seller decides that they're going to advertise their property on Facebook and you become known of it, you must enter now that property on the MLS within 1 business day. So I just want to make sure that you understand that. And if there's any other questions, please check with your broker, check with your local MLS. Make sure that you understand the rules and regulations of Clear Cooperation. Let's go on to Section 14, Lockboxes. Section 14 talks about lockboxes and whether or not the seller will allow you as the listing broker or agent or brokerage to put a lockbox on their property. Most of the time, this is not even an issue. You get a lockbox, it's secure, people are okay with that. They realize that only realtors, for the most part, have a lockbox, and there's other security measures if you're not a realtor that you can't just walk up to a lockbox and get the key. They understand that. But I want to bring up something to your attention. It says, owner acknowledges and agrees that neither broker nor broker's agents, subagents, or anyone showing the property through the MLS shall be responsible for any damage to or loss of personal property or to the realty except such damage or loss may be caused by the negligence of such party, by the negligence of the person showing. Okay? It says on page 4, top of page 4, owner further acknowledges that broker nor MLS is an insurer against the loss of personal property and agrees to release broker and MLS from any responsibility therefore. So there's always going to be some protection in there and for some liability when people are being given to access to somebody's house. And so they just need to know, the seller needs to know, we're not an insurer. If there's no fault to the party, we're not responsible for that. So if there's damage that are caused for an accident, by the way, we're not responsible for that. So hopefully you understand that. Hopefully the seller understands that. Again, not hard to understand, but just I wanted to bring that to your attention. Let's go on to section 15. So section 15, other offers, says owner understands that the broker's responsibility to present offers to purchase to the owner for owner's consideration terminates at the time of closing of the subject property or expiration of this agreement, whichever occurs first. Not a whole lot there. You don't have to present any offers if the property is closed. Pretty simple to understand. Let's go on to section 16, which is a new section, marketing the property after accepted offers. Section 16, basically renamed. I said it's new because we didn't have those words in there before in our old agreement. Section 16, marketing the property after accepted offers. The broker shall not continue to market the property after an offer has been accepted unless requested in writing by the owner to do so. Now, it is my personal and humble opinion that properties should always be marketed until they're closed. Anything can happen. We have contract fallouts all the time. The property should be marketed. Now, is it going to be marketed as active? No. It's going to be marketed as whatever the status is, contingent or pending, whatever the case may be. But it's still being marketed. So just make sure that you do your seller right. And again, things can fall out right before closing, and you may not want to lose that marketing time for your seller to make sure you get that property sold. So let's go into section 17, no control of commission rates or fees. Our company charges a certain dollar amount, and the policy allows our agents to drop to a certain amount without broker permission. And then if you drop below a certain amount, you will need broker permission to do so. That's our basic policy. Now, we have no idea what other brokerages charge. We have no control over what they charge. What we charge is what we charge, and brokerages can't get together to control that commission rate. It's not a fixed thing across the board. If they interview 5 other brokerages, they could get 5 different listing rates or fees. So you need to make sure that the seller knows that we don't know what another listing brokerage would charge. If they say they got another charge because they interviewed that person before you, that's fine. What we charge is what is in our policy, and we don't get together with other brokerages to fix commissions. That is against federal law and antitrust. Let's go into section 18, maintenance. I've had some changes in this particular section. As a matter of fact, it used to be another section number. Now it's section 18, maintenance. And I'm going to read it because they have stricken out several things that were in there before because it did not comply with our repair procedure in our agreement to buy and sell. So they've taken things out that were not in the repair procedure. So I'll read the whole thing. Maintenance. Owner agrees to maintain the property, including lawn, shrubbery, and grounds until the day of closing or possession, whichever occurs first. Owner also warrants that all heating, air conditioning, electrical, plumbing systems, as well as built-in appurtenant equipment or appliances shall be in operative condition on the day of closing or possession, whichever occurs first. And you see there, those other lines have been stricken out of the contract. So when this contract becomes clean, right, and it's not just a draft that we're showing here on this, you will not see those particular lines in that section anymore. Let's go on to section 19, the agreement to sell. The agreement to sell. When a buyer is found for said property, the owner shall enter a written sales agreement, which will contain the terms and conditions of sale, the customary provisions as to the examination of the title, the curing of any defects in title, the proration of taxes, rents, and applicable property expenses. Basically, a line to say, we're going to list your property, and then we're going to get you into a contract for sale with a buyer that will explain all the terms of how the passing of your property is going to go to the next buyer. So not a whole lot there. They just got to understand that a contract hopefully is imminent and will be coming, because that's the way a property is transferred when we list it. Paint. Not a whole lot to discuss here. If the property was built prior to 1978, all listings need to have the federal lead-based paint document signed by all parties and the agents. So just prepare your seller, if they have a property built prior to 1978, that a lead-based paint is going to need to be filed. Now, most of the time, sellers do not know whether there's lead-based paint in the property. If they do, and they have records of that, that document will have check marks to say the seller has knowledge, the seller has documents, all the above. Most of the time, we don't see that the seller has any knowledge of that. Just make sure you let your sellers know they need to fill this document out if the property is built before 1978. Basically, even before I go into reading it, basically what this clause allows is that if there's a problem that arises between the seller and the listing agent or the listing brokerage, that the National Association of Realtors has set up mediation across the country, and especially here in Greenville, we have our own mediators and what they call ombudsmen to mediate certain circumstances that don't necessarily rise to the occasion of going to actual physical court. That the seller and the agent or the listing brokerage can get together with mediators to determine, what happened, how can we keep from going to court to mediate between the parties. So there is actions and occurrences for that with our local association. So they need to know that they do have some rights, and that the National Association of Realtors has put into place this particular program to keep people from having to spend hundreds and thousands of dollars of going to court. These things can be taken care of. The one section in there, it says, disputes shall include representations made by owner or broker in connection with the services to which this agreement pertains, including without limitation allegations of concealment, misrepresentation, negligence, and or fraud. Any agreement signed by the parties pursuant to the mediation conference shall be binding. This mediation clause shall survive for a period of 120 days after the date of closing. So there is a time frame there. Just make sure that everybody understands that. But it is also binding once it's completed by the mediators. It's a pretty short section as well. It says, owner and broker agree that the property is offered without regard to race, color, religion, sex, handicap, familial status, or national origin, and is listed in full compliance with local, state, and federal fair housing laws. So we avoid the very mere essence of discrimination when we sell property and when we bring buyers to property. So please let your sellers know. No discrimination whatsoever. It says the parties agree that this agreement may be communicated by use of a fax or other secure electronic means, including but not limited to the internet, and the signatures, initials, and handwritten or typewritten modifications to any of the foregoing shall be deemed to be valid and binding upon the parties as if they were original signatures, for example, signed in blue ink, original, not copied. Initials and handwritten or typewritten modifications were present on the documents in the handwriting of each party. So if it's done digitally, if it's done through fax, done through email, it's the same exact thing as if it was an originally signed document. That's pretty standard here in 2020. So the parties agree that brokers may take action to enforce this agreement or collect any associated costs, fees, and damages. Owner agrees to reimburse or indemnify or pay all brokers' costs in enforcing this agreement or collecting costs, fees, and damages, including any incidental expenses or attorney's fees. So again, this document is meant to dissuade sellers from just merely suing and trying to collect fees from the listing agent or the listing brokerage. If there's a problem, they want you to go to mediation, keep everything out of court, but this is an enforceable document. Therefore, it's enforceable by the seller toward the listing company or listing brokerage or listing agent, and it's also enforceable by the listing brokerage to go after the seller if they found out that the seller did something wrong. So this is a legal and binding contract. I'm going to read this, but I'm also going to make some very specific statements. It says, seller agrees that broker is not responsible for obtaining or disclosing information in the South Carolina Sex Offender Registry, and no course of action may be brought against the broker for failure to obtain or disclose sex offender or criminal information. Seller agrees that they have the sole responsibility to obtain their own sex offender, death, psychological stigma, clandestine laboratory, and crime information from sources, for example, law enforcement, private investigators, the internet, the web. The seller may obtain information about the sex offender registry and persons registered within the registry by contacting the local county sheriff or other appropriate law enforcement officials. Here's what I want to say all about that. Okay. It says it's not your responsibility for obtaining or disclosing. If this conversation even comes up, simply say, I refer you to the local sheriff's office for anything regarding this. We don't want to get ourselves involved in some lawsuit stating that somebody is or somebody was or somebody's living in some neighborhood that could be on there. That is just something we don't even want to go toward, and steer clear away from that information. Let your presence be known and let your opinion be known. If this is important to them, contact their local law enforcement or sheriff's association to gather that information. So let's definitely read this so we understand this. Seller irrevocably conveys any and all of the seller's audio, photography, and video rights in perpetuity, or in other words, forever, involving seller and seller's family and seller's property to broker for marketing and advertising and any other purpose deemed necessary by the broker. So basically the way I understand this is when a photographer goes in there and there are other photos within the property that if the seller wants to leave those photos up in the property and you're a photographer and those photos are taken and a picture is taken of another picture, they can't come back to us and say that there's a violation of copyright. That's what this is trying to protect. They're conveying those rights to us for taking photos for anything that's taken within their property. So hopefully that explains that. If not, I would highly encourage you to contact the legal department of the South Carolina Association of Realtors for further information on that. Because again, this is still so new. I've not even experienced anything involving this. So if you have more questions about this, I would defer you to the South Carolina Association of Realtors legal department and legal hotline. This is pretty important considering everybody has a camera now. It says seller agrees to abide by any laws and regulations regulating audio and video surveillance of the property and persons entering the property, including agreeing not to use any surveillance in areas where persons have an expectation of privacy, such as restrooms. Seller agrees that the broker may or may not disclose potential surveillance as broker deems necessary, including signage on the property and advertising or in any advertising and marketing. Okay, so we're teaching our agents just automatically assume that there is surveillance and or recording audio equipment and video equipment in every house, and to hold all the discussions and statements until you're off premises of the property. That's specific in the buyer's agency agreement. But this is giving the agent the authority to disclose it or not to disclose it. And I'm in hopes that most sellers will say, yes, you have the authority to say that I have surveillance equipment in my house, but there could be some that say they don't. And so you either check may or may not disclose it. I would highly encourage you, if they do give you that permission, that you do obviously put that in the member remarks of your MLS. So everybody's aware there is surveillance in the property, and so that there's not a problem that arises when a property is being shown. It says other terms and condition, and it's got some lines in there. I guess that's going to be between the seller and the listing brokerage. What other types of conditions? I mean, I can think of one right off the bat. If you, as the listing agent and the seller, agree to maybe certain price reductions along the way, this may be a decent area to put that in. For example, if the listing price is set at one thing at listing date, and you and your seller decide that if the property is not under contract within a certain period of time, that the listing price shall be reduced to a certain amount, and the MLS will be updated on that certain date that you choose. That's a section that I would probably use for that. I'm sure that you can probably think of other conditions or other terms that you may want to put in that section as well. But there it is for you to fill it out and agree to. So we will go on to the bold writing right underneath that section. Okay, so this section is not really numbered. So this is, we're referring to the bold, all in capital letters right below section 29. And I'm going to read it because anytime something is bold and in all caps, it's probably pretty important. So it says, the undersigned hereby warrant that they own the property, I hope so, and or have the authority to execute this agreement. And I hope so for that too. This is a legally binding agreement. Owners shall seek further assistance if the contents are not understood. Let me stop right there. They shall seek further assistance. If there's a problem with a seller not understanding or questioning something in this agreement, we need to refer them to legal, to an attorney, somebody else with legal authority to explain this document to them. We are not attorneys. We cannot practice law. And if there's a problem regarding this particular legal and binding agreement, they need to seek legal counsel if they don't understand or they're not explaining it to the point where they understand it. If they don't agree with something, if they don't want to sign something, it'd be a good idea for you also to have them contact an attorney as well. I'll continue on. Owner acknowledges receipt of a copy of this agreement. Okay, so when they sign it, you got to give them a copy, and a copy of the South Carolina Disclosure of Real Estate Brokerage Relationships form. Again, they've already signed for that or initialed for that on page 1, but they're acknowledging it, receiving it, and you've given them a meaningful explanation of what that form says. It also says owner agrees to receive communications from the broker at the email address, phone, and fax number listed below, and that's where the owner is going to sign, date, and time. Provide the email address, especially, given the fact if something happened to you, the broker in charge needs to know exactly how to get a hold of its listing clients. Other than that, you go on and continue to fill the rest of that out, and the real estate firm there, you sign the document, you date and time. And remember, on the bottom of this page too, there's also owner initials and broker initials on the bottom of page 5. That will conclude the training on Form 220, the exclusive right to sell. Let me end, as always, with my disclaimer. So as I mentioned at the very beginning of this video, I am not an attorney. I am simply a broker in charge, putting out this video to help the agents of Berkshire Hathaway Home Services Seed and Joiner Realtors have them get their questions answered about what something means or how to explain something in this section or in this document completely. And it's also for the use of other agents across the state of South Carolina that are licensed in real estate under South Carolina law. Again, I am errant. I'm not God. If I've made a mistake, please kindly let me know. I will correct it. But I want to stop and say this. If you do not work as an associated licensee underneath my license, and you feel that I've said something that you may disagree with, or that you know that your broker disagrees with, please, I implore you, go with what your broker in charge says. Please, just contact them. If I've not explained something appropriately, please go back to them and have your broker explain it. I'm always going to push everybody back to their broker in charge. Again, the way I interpret something may not be exactly the way your broker in charge interprets something. So check with them and make sure that they're good with everything that may have been taught in this video. And if they're not, go by what they say. And I implore you as well, I've said it a couple times, if you think I've said something wrong, or if there's a problem with something that I've said, please contact the legal department or the legal hotline of the South Carolina Association of Realtors and get their interpretation and their take. This video is not in any way, shape, or form endorsed or even any way by the South Carolina Association of Realtors that's had me do this. They have not. Okay, this is again a training for our particular company. So I just want to let you know that right up front. SCR has nothing to do with this video, but they are a great resource to get your questions answered if this video has not. I hope you have a wonderful day. I hope to see you around the real estate corner. I hope to do business with you soon. Take care. Take care of yourself. Bye-bye now.